Okay. My name is Norman Effman. The first thing to be somewhat transparent about my role here is I want to congratulate the last speaker. He was exceptional, and I am proud to be his father. So he must have been brought up well. So Jason, tell your mom that she probably did a good job. The other thing to be transparent about is my role with respect to the awards committee. This is my first year as chairman of the awards committee for mandated representation. For those of you who know me, you know I've been doing the same work for the criminal justice section for several decades. In fact, I tend to have lots of friends during awards season. It's an important part of my life in realizing how many people appreciate recognition from their peers. There's a big difference, however, between the awards given, and this is a joint meeting between criminal justice section people as well as mandated representation people and the rest of you, but there's a difference in our focus. The criminal justice awards involve legislators, prosecutors, judges, defense attorneys, both institutional practitioners and private practitioners. So it is a broad spectrum of individuals in the criminal justice system, whereas the awards given at this meeting is for mandated representation. It focuses on those people in the trenches fighting the fight every day and representing indigent individuals in situations where representation has been deemed mandated. The committee itself was formed in 2005 by then State Bar President Thomas Levin when he appointed Vinnie Doyle as the chairman of a special committee to ensure the quality of mandated representation. That particular group, starting out in 2005, created the standards that the State Bar has adopted and that ILS, Indigent Legal Services, has adopted as what would be best practices for representation in constitutionally protected areas. Vinnie Doyle had a lot to do with setting this up and also created something pretty much unknown by the State Bar at that time, and that was pretty much a free CLE for attorneys in both the criminal sphere and in the family court sphere to provide a yearly free CLE to individuals. Now that's changed. It's now $25, I think, and that's to ensure that if you sign up for lunch, you show up. But you know, if you show up, you get lunch for $25. Not a bad deal. In creating what is now the mandated representation committee, Vince had the idea that we should focus on those people that are providing the services and honor them at this annual meeting, that we can provide significant CLE credit and share the knowledge of experts with those young attorneys, especially, who are starting out in the difficult task of representing individuals in constitutionally protected areas. So the awards were his idea, and to recognize our peers. And the interesting question is the Denison Ray Award. Denison Ray was an activist in the civil rights movement in the South for many years, I think in Mississippi and Alabama primarily, but he was a civil litigator for the most part. I don't understand the difference between, a civil rights constitutional lawyer and a criminal defense lawyer. They kind of merge in my mind. But that was Denison Ray. He was involved in civil litigation in the South. He was a graduate of Auburn and then went to NYU Law School. And his his activity during the later part of his life was all in the Capital District. So he was with a legal service corporation that serviced the Capital District. So it's fitting that this award is presented in Albany, which was his home base. He died when he was only 63 years old, and it was a heart attack. I guess the business that those of you who are in public defense and institutional providers and 18B lawyers, be aware that he died at the young age of 63. And believe me, that's young from where I sit. And the reason that you only hear my voice, by the way, and don't see me, is that I'm recovering from surgery, and to see me would be, well, it would be an act of self-pity, and I was just looking for sympathy. So I chose to be a voice rather than a picture. So that's the way that mandated representation ended up presenting the Denison, the Ray Award is kind of interesting. I tried to track it down. This award has been given by the State Bar since almost the time of his death, which was 1994. But it's been funneled to various parts of the State Bar throughout the years, whether it was the legal aid section, but it ended up being part of that section of State Bar that deals with pro bono representation. And that's where I think mandated came in, because at the time that mandated took over the presentation of the Denison Ray Awards, the State Bar liaison to mandated was in fact the State Bar liaison to the pro bono section, and that was her primary duties. So I believe she naturally utilized mandated as the proper home for Denison Ray. So with that in mind, and with the transparency that I am the chair of both awards committees, and therefore that means one thing: I am not getting any awards ever while I maintain those positions, because I am not eligible for any awards. That's the downside. The plus side happens to be the wonderful people I deal with in both award sections. And in this section, I think Leah has already given you the names of the awards committee, but Patricia Worth, Sue Lindenauer, Andy Kossover, and I went through the nominations. And I think the slate of recipients for this year's awards is outstanding. I mean, I was amazed looking at the list of people that have received awards over the years. I thought we covered everybody, but I mean, just for example, Bill Leahy, who has done so much to change the very foundations under which we practice, has never received an award from either section, and that's unheard of, since he was a primary mover in what is now a vibrant part of criminal justice, and that is the criminal justice section, the public defenders, the 18B lawyers. Everything that's happening now can be traced back to when Jonathan Gradess at NYSDA pushed for a system that ended up with Bill Leahy taking over ILS and creating at least a network for all of us to improve the mandated representation that we're all involved in. So with those opening remarks, and I have one further privilege I want to take advantage of as being chairman, I want to not only thank Jason for his presentation and making me proud, but also a shout out to his wife, Ingrid. It's her birthday, and she is a former public defender in Rensselaer County. So with that, let me turn the program back to the people that are running the show, and thank you for listening.
Thank you, my friend Norm, and thank all of you for joining us for this very important awards ceremony. I'm very fortunate to be given the opportunity to present Bob Dean with the Denison Ray Award, to be part of Mandated Representation's community's expression of immense appreciation for the work Bob has done for us, mandated representation providers, and the clients and the individuals that we serve. To quickly get a sense of how deserving Bob is for this very important award, just take a look at the individuals who submitted letters in support of Bob's nomination for this award. There's Andrea Nieves, who worked closely with Bob in various policy initiatives. There's his longtime colleague at the Center for Appellate Litigation, Mark Zeno, and there's Cindy Feathers, who has worked with Bob not only as a staff member of Cal, but also as her current position as Appellate Director of New York State Office of Indigent Legal Services. All three not only know firsthand what Bob has accomplished, they themselves have made major contributions to the world of mandated representation. They know what they're talking about. The common theme among Cindy's and Mark's and Andrea's letters in support of Bob is not only did Bob create one of the finest appellate defender institutions in the country and led that institution for 4 decades, Bob, with his genius and doggedness, greatly improved the quality of mandated representation through the entire state. As to Bob's work at Cal, Mark described it this way. What separated Bob and came to define Cal from other appellate defenders was the belief that clients deserve more than just a brief and an oral argument in the first department. Under Bob's leadership, Cal pioneered the idea of specialized programs to better serve its clients, ultimately developing the idea of a full-service appellate defender. Cindy shared similar thoughts about Bob's work at Cal. Cindy described Bob as an inspiring director of a defender program who insisted unwaveringly on high-quality representation. Attorneys received outstanding training and then ongoing supervision to ensure that viable issues were identified and effectively framed. Briefs were comprehensive and persuasive, and attorneys were fully prepared for oral argument. For cases in which full relief was not achieved in the first department, Bob ensured that leave applications to the Court of Appeals were carefully crafted, and the office achieved an enviable record of leave grants. As to Bob's work outside of Cal, Andrea summed it up just perfectly. Quote, Bob rightly realized that the role of the defender cannot be limited to courtroom advocacy. If we are truly to improve representation, we must reform harmful discriminatory laws so that defenders have the tools we need to fight for our clients. Bob held numerous leadership roles in several different statewide organizations, the Bar Association's Committees on Mandated Representation in Courts of Appellate Jurisdiction, the Chief Defenders Association, and ILS's Appellate Council. This allowed Bob to tackle important criminal, child welfare, and racial justice issues by seeking legislative reforms, providing robust annual training programs, and setting high standards and best practices for appellate defenders. We all believe in the maxim, justice delayed is justice denied, but Bob walked the talk. Bob participated in drafting and then successfully lobbied for a change in the criminal procedure law that greatly streamlined the procedure for the assignment of appellate counsel. And then there's Bob's remarkable efforts to rectify a horrible appellate division decision that unfoundedly questioned the ethics of an appellate defender's zealous advocacy. The attorney was not a member of his office, and his office did not even practice before this particular department of the appellate division that had issued the decision. Yet Bob was deeply troubled by the harm that was being done by the decision. The attorney's stellar reputation was being unjustifiably tarnished, and the decision was having a chilling effect on zealous appellate advocacy. Bob, before my eyes, orchestrated a successful statewide effort to have the appellate division withdraw the decision and replace it with one that rightly leveled no criticism at the attorney's advocacy. For several years, Bob has authored and distributed throughout the state of New York his Court of Appeals update. The update served to alert appellate and trial attorneys alike to potential changes of criminal procedure law and law itself, which allowed them to fashion arguments in their briefs and motions in anticipation of new law. Bob's fellow members of the Indigent Appeals Subcommittee of New York State Bar Association's Committee on Courts of Appellate Jurisdiction have described Bob as, quote, courageous, the most impactful leader in the world of appellate defense in over a decade, and, as an aside, a snappy dresser. I don't know about the snappy dresser thing, but what I can say, Bob, and what I do say, is you're aptly named. You truly are the Dean of Appellate Defenders. Congratulations, Bob. Step on up. We got to do a photo? Oh, yeah. My honor.
Okay, so I have to give a speech now.
Yes.
Okay, so that's a tough act to follow. Thank you, Drew, for those kind words. I'm going to be as brief as possible because those of you who know me know I'm not much of a public speaker outside of the context of oral argument. In fact, the only time I'm in my comfort zone speaking publicly is when I'm facing and looking up at the faces of 5 appellate division judges staring down at me with looks of utter disbelief. That's my comfort zone. So I'd like to thank the Center for Appellate Litigation, my former colleagues for doing their excellent work that made me look good. And I'd like to thank the Committee on Mandated Representation, not only for giving me this award, but for actually being the best committee that I ever chaired, which is actually saying a lot. I'd like to thank my wife, Lynn, who many of you know, for standing by me for the last 40 years. And lastly, I'd like to thank Miss Giesling, who none of you know. And in fact, I never knew her first name. She was my kindergarten teacher. And as you all know, most of what you need to know in life to get along, you learn in kindergarten. And to Miss Giesling, I will say that I do not resent you for, in my report card, under the category of works and plays well with others, checking the box needs improvement. I really took that to heart, and I've been working on it for the last 66 years, and I'm still working on it. So anyway, thanks for the award.
Hi, everyone. I am Patricia Pasner. I'm the attorney in charge of Appellate Advocates, a New York City criminal appellate indigent defense organization founded 27 years ago by Lynn Leahy. I am beyond pleased to introduce Alexis Ascher. Alexis has been a member of Appellate Advocates for 21 years, first as a staff attorney and now as a supervisor. Alexis's strength as an appellate attorney is unparalleled. We have a brief bank in our office that contains filed briefs of every case we submit to the courts. When new attorneys first join Appellate Advocates, I urge them to read through the briefs to get a sense of how we write in the office. Without fail, I find myself immediately suggesting to new attorneys to read Alexis's briefs. Alexis has a way of writing a statement of facts that is credible, comprehensive, engaging, and sympathetic. By the time you get to the legal analysis, you find yourself believing that a dismissal or a new trial is not only the right outcome, it is the only outcome the court should possibly find. Alexis not only possesses this truly remarkable narrative skill, she is able to do the thing that often naturally talented people cannot. She can teach it and translate that skill to others. Alexis is always willing and excited to teach legal writing to a new attorney, and you can immediately see improvements to their writing after working with her. Attorneys leave the supervisory experience excited to write more and passionate about their ability to make a difference on appeal. For the majority of her 20+ years at Appellate Advocates, Alexis was primarily focused on direct appeals. But right before COVID hit, she took on an additional role as co-director of the Domestic Violence Survivors Justice Act practice area, seeking sentence reductions for those clients who suffered the most severe of domestic abuse. Despite the logistical difficulties the pandemic obviously caused, Alexis took on the challenge of managing a brand new practice area while continuing to be a leader in direct appeals. Her success in DV practice is astounding. She has helped to bring about 8 successful sentence reductions since the recent passage of the statute in 2019, and has truly inspired and guided the DV team, many of whom are here today and were her enthusiastic nominators for this award, to continue to push forward novel and compelling arguments in the trial level and on appeal. To note, Alexis did this all while continuing to litigate her own heavy appellate caseload, supervise other attorneys, and somehow managed just 6 months ago to secure an exoneration for her own actual innocence client, Darrell Williams, after he was wrongfully convicted over a decade ago. Yes. I will end with this. Last week, I was reading a staff attorney's DV motion, and it was the first one that I had personally supervised. I immediately pulled up another DV motion recently written and filed to not only make sure that I didn't miss anything, but to guarantee that everything possible we could add to the motion to make it perfect was included. And at that moment, I laughed to myself, because without thinking twice about it, that finished motion I pulled up to use in order to make the new motion the best it could be was Alexis's. That her written product continues to be the gold standard at Appellate Advocates tells you all you need to know about why Alexis is receiving this award today. So with that, Alexis, come on up.
Oh, wow. I didn't know what this would feel like, but it feels really great. Thank you, Patty, for your kind words. Really, there are no words to describe how much I appreciate being here, but I have to start with Lynn Leahy. She's where I began. She gave me a chance 20 years ago to work at Appellate Advocates. I'm not sure either one of us thought it was going to work out, but her trailblazing, her advocacy, all the writing that, Patty now speaks so highly of me, all came from Lynn and her training, and she really taught me how to be the kind of lawyer that I am today. So for that, I'm appreciative. And Bob, you were some of my early trainings as well, so thank you. It's really with all my mentors at Appellate Advocates, Lisa, everybody, you all know who you are. The reason why I was able to take on this challenge of the DVSJA is because of all the support that I get where I work, and the yeses to my crazy ideas, and this fabulous team who nominated me to be here today. The DVSJA did not work out yet, as we hope it will be, but we persevere and we challenge and we support, and our clientele are the most vulnerable victims, and it's an honor to work with you every day and help our survivors of domestic violence try and get out now where they should be. And I want to thank the Bar Committee for this. This is huge. I feel great. It's important to recognize the work that we do as public defenders. It's a hard job, but it's a great and rewarding career. And this is for my clients. I hope I continue to live up to the excellence. Thank you.
Our next award presentations will be virtual, so we ask for your patience and direct your attention to the screen, and AV will get those up and running.
Hi, everybody. I'm so sorry that I could not be with you in person, but I'm really honored to be able to present the award to Corey Stoughton. For those of you who have never met Corey or watched her argue in court, debate across an aisle, walk the halls in Albany, you're missing out. She's really a force for good, and her entire career as a litigator here in New York, in DC, and even across the pond in London sort of demonstrates her deep commitment to marginalized communities and people of color everywhere. You know, here in New York, you can't talk about the Sixth Amendment right to counsel or caseload standards or indigent defense funding without talking about the work that Corey led. In 2007, when she was at New York Civil Liberties Union, she led that team that brought Harel Herring to life. HH, as we sort of say, shorthand. And if it wasn't for HH, there would be no statewide implementation, because the settlement that Corey and that team brought to the table that allowed for new caseload standards, increased funding, quality improvements, didn't only benefit the counties in that lawsuit, it set the pathway and set a standard that's statewide now that we operate under as public defenders and assigned counsel. It set the standard for conversations happening across the nation about caseload standard relief and what it takes to fund public defender systems. But even beyond Harel, even beyond the Sixth Amendment right to counsel and funding, Corey has fought for police accountability and transparency. She does it here at Legal Aid Society as the attorney in charge of our Special Lit and Law Reform Unit, and she did it in DC as special counsel when she was appointed by former President Barack Obama to work at DOJ, really looking at the way in which we move the conversation about policing and policing of BIPOC communities. Here at Legal Aid, at home, all of us, watch and learn from Corey every day as she balances supervising teams, teaching systemic litigation, bringing on interns, and shaping the strategic plan of our special litigation unit. And at the same time, she's doing all of that, she's rolling up her sleeves and jumping right back into litigation. In fact, she's doing 3 days of depositions right now on a case that she's working on. During COVID, she and the team at Legal Aid literally worked around the clock to file direct and class action writs to release hundreds of people from Rikers Island and in some upstate prisons because death was literally around them as we faced the pandemic. And what did that prove? We took that, and Corey took that lesson, and now reinforces every day that we can decarcerate our jails and prisons quickly. We just have to be dedicated and not give up the fight. So here's to you, Corey, for never giving up the fight, for always thinking about how systemic litigation must be tied to direct client services. And thank you. Thank you on behalf of us at Legal Aid, but more importantly, on behalf of all of us that do mandated representation.
Well, thank you so much for the honor of receiving this award from this committee of the State Bar, which itself has done so much for the cause of quality representation and access to justice. And I'm so sorry that I'm not able to be there with you, but as you're doing this, I'm taking a deposition in another case, and I know you litigators out there will appreciate how hard it is to nail down the schedules of those hard-to-get witnesses in civil litigation. Receiving this award is such an honor, but you know, the myth of awards like this is the myth of individual heroism. And there are so many people who deserve this award as much, if not more, than I do, especially Danny Greenberg and Gary Stein and Christy Blaze, all currently or formerly from the law firm Schulte, Roth & Zabel, who are our co-counsels on Hurl Herring, and who put as much sweat into that litigation as I ever did and became great friends along the way. And the whole team at the New York Civil Liberties Union, including our fearless leaders, Donna Lieberman and Chris Dunn, and the countless junior attorneys who, like junior attorneys everywhere, did collectively most of the labor and get none of the glory. And two former great chief judges of the state of New York, Jonathan Littman and Judge Kaye, without whose bravery and honesty in calling out the problems with public defense in New York State, none of this ever would have happened. And of course, the late legend, Jonathan Gredas, who was truly the inspiring force behind all of this work and remains an inspiring force to me in my career, even to this day. Hurl Herring was a great step forward in access to justice in New York, and reflecting on its success is also an opportunity to assess where we are and how far we have yet to go to really fulfill the spirit of Gideon and the Sixth Amendment right to counsel. All across the state, people who labor for low-income clients in criminal court and also in housing court and in family court are still fighting for fair wages and resources to ensure a level playing field against the state. At Legal Aid in New York City, we are still fighting for the fulfillment of promises of funding fairness made years ago. The State Bar was forced to sue to compel the first rise in 18B wages in decades. Welcome discovery reforms in 2019 really transformed our practice, and yet it wasn't until this year that anyone thought to put the resources behind what was necessary to truly transform and support the transformation of that practice. We can really take nothing for granted when it comes to the right to counsel. But the lesson of Hurl Herring is that when we fight, we win. We established the right to counsel at arraignment. We established statewide eligibility standards and statewide caseload standards and hundreds of millions of dollars in state funding for public defense, all things that in 2006 people thought might be impossible. And we did that by building the broadest coalition possible. We did that by bringing together defenders and advocates and judges and impacted people and our champions in Albany with an integrated litigation, communications, and policy strategy. And so thank you so much for recognizing that work today. This award really is for all of the folks, many of whom are in that room today who were part of and continue to be a part of that coalition. So here's to you all, and thank you once again.
Good afternoon. My name is Patricia Worth. I am the director of the New York State Office of Indigent Legal Services, and I am here to introduce Bill Leahy for his award for outstanding achievement in promoting standards of excellence in mandated representation. Bill Leahy is a lifelong public defender, trailblazer, and tireless advocate for the resources needed to uphold standards of excellence in mandated representation. He began working in public defense 5 decades ago when, after graduating from Harvard Law School, he took a position as a public defender in Massachusetts. In 1984, he was chosen to be the first Deputy Chief Counsel for the Public Defender Division of the Massachusetts Committee for Public Defense Counsel Services. And in 1991, he became the Chief Counsel of CPCS, a position he held until 2010. In 2011, Bill brought his extensive defense and leadership experience to New York, becoming the first director of the newly created New York State Office of Indigent Legal Services. He successfully navigated ILS through the uncertainty, a lot of uncertainty, of its early days by coupling a deep commitment to improved quality mandated representation with a willingness to listen and to collaborate. Though clear-eyed in ILS's mission, Bill was never strident or uncompromising. Rather, he worked to forge strong relationships with chief defenders, state and county officials, and community leaders. In so doing, Bill advanced what he considers to be an essential component of public defense reform, and that is elevating and empowering public defense leaders to become influential advocates in their communities. Bill led ILS with a keen understanding that there's more than one path to meaningful reform. The 2014 Harrell Herring settlement offered one such path. Though limited to just 5 counties and failing to address the crisis in family court representation, Bill saw the opportunities the settlement offered, and on behalf of the ILS board and office, accepted responsibility to implement it. ILS's success in implementation led to the 2017 legislation extending the settlement initiative statewide. As a result, under Bill's leadership, state funding for improved quality mandated representation grew from $79 million in 2011 to over $350 million by 2021. Bill's quiet, magnificent zeal continues to be felt on many levels. He believes in the profound importance of defenders in achieving a just system and just society. He cheers the work of public defenders and ILS staff, and he does all of this with deep warmth and caring. Bill is passionate about the public defense function, and he cares deeply about public defenders. But in the end, for him, this is about serving our clients, the vulnerable New Yorkers who depend on us to protect their rights. Bill's legacy as ILS's founding director will endure, and his commitment to excellence and mandated representation continues to inspire all of us. And so I'm honored to present this award to Bill Leahy. Thank you.
Hi, I'm so pleased to accept this award today. This happens to be June 2nd, the second anniversary of my retirement as ILS director. And I want to say that I'm very grateful to Patricia for her lovely words and kind words of nomination. And I want to thank everybody I worked with and we at ILS worked with over the years to get the process of improving mandated representation in New York State off the ground and give it a stable foundation and a promising future. I think the keys, I came to New York from Massachusetts, and Massachusetts was a statewide system. You didn't have to worry about county executives, county legislators, New York City, rural county divides. And New York was, for me, both very challenging and just incredibly great fun. What a way to spend your 60s and early 70s. So now we've made a lot of progress that's been continuing under Patricia's leadership and all the other leaders of all the other organizations all across the state. And that is fantastic. So I think what I want to just say today is a couple of comments about what I think is absolutely critical to continue and to reinforce. We've got, number one, standards of excellence for mandated representation. They're largely in place. A lot of work has gone in at every level, from the state level to the county level, and most especially to the county provider level, the public defenders, the conflict defenders, the assigned counsel programs. All of them have made great strides in upping their game, elevating their level of representation. The state has finally started to provide some meaningful support. When I say finally, I mean over decades that had not happened. And what is essential for this progress to continue and to expand and to grow is for a continuation and a reinforcement of the ties that have been built. When I think back to starting out at ILS as the only employee, and then teaming with Joe Worsham as the only two employees for a long time, and then working with the state bar, the county bars, the New York State Association of Counties, the New York State Defenders Association, and then later the Chief Defenders Association of New York. All of these entities, and of course, the Assembly and the Senate and the governor, and the governor's staff, and the judiciary, and including the chief judge who chairs the ILS board. And so you have all these entities. It's a real pastiche in New York of people who have primary interests, which are often in conflict with one another. And the challenge is to generate a cohesive and vibrant focus on high quality public defense, high quality mandated representation. I use public defense broadly to include parental representation, of course. And this is what has to continue. You can't take it for granted. The role that all of these organizations I've mentioned and others have played has been essential in the progress we've made to date. With the continuation of that commitment to listen, a commitment to call, a commitment not to hide in your foxhole and advance your primary interests. Of course, everyone's advancing their primary interests and fulfilling their primary obligations, but they also have to work together so that all the boat is rowing in one direction with all the oars pulling in unison. That's the secret sauce to success in New York. From afar, now that I'm even back in Massachusetts, it looks like the impossible state. I mean, how does anything get done? But wow, have we accomplished a lot. And I am so happy to see that accomplishment continuing 2 years into my dotage, or at least my retirement. So have a great day. I wish I could be with you all in person. And I'm glad you can be in person. And I'm really, really proud of everything we together have done. I'm very proud of what has happened since my retirement. Very proud of the continuing progress and the continuing cooperation. So have a great day, everyone. And thank you very much for this completely unexpected honor.